Appeal in the matter of Joint Council for the Welfare of Immigration and Secretary of State for the Home Department.
Yesterday we left off when I was in the process of dealing with Sir James's criticisms of the judge's reliance on evidence, or a number of pieces of evidence, to found his conclusion that there is discrimination, and that discrimination is on grounds of race and nationality. Just a couple of points to add to the matters I addressed yesterday in response to those criticisms of each piece of evidence. On the government's own evaluation, where the criticism is that the judge failed to rely upon that, I made the point that it wasn't statistically significant. Yep. Just for your lordship's note, that is acknowledged in the evaluation itself at page 226 of the supplementary bundle. A matter I didn't touch on, and neither did Sir James, but it is in their skeleton, is the criticism of the mystery shopping exercise because it failed in the second exercise, which was the one that established to a statistically significant extent that there was ethnicity discrimination in respect of British nationals who didn't have passports. One of the criticisms made is that in that second evaluation, only paired data was used and not unpaired data was used. And that, an explanation has been offered by Mr. Hickman from Myriad, who was responsible for conducting the statistical analysis. He actually provided a very clear explanation in his first report at page 34 as to what is meant by paired and unpaired data, and as to why paired data is the more valuable and reliable indicator. And it's very simple. What's meant by paired data is that the landlord is presented with a pair, the relevant pair that is being tested, and therefore it is the same individual that is applying consideration to the two cases. Unpaired is where you're trying to relate responses from landlords who are not presented with the pairs of individuals you're seeking to compare. So for obvious reasons, the paired data is going to be more accurate. As I say, that was explained at paragraph 34. A fuller explanation is then given, page 34, and a fuller explanation is given by Mr. Hickman on pages 66 to 71, and that was in response to the defendant's criticism. So I'd ask your lordships to read that. And another small point, that at page 132 of the supplementary bundle, one can see that appealing a notice issued by the Secretary of State to a landlord costs £235, which is a figure that was selected intentionally to be higher than the category A fine itself, to which they'll be subjected, precisely so they won't appeal. So there's a further disincentive to be faced with that sort of cost. So in my submission, none of the criticisms levelled at each individual piece of evidence that the judge relied upon hit their target. They do not knock out that piece of evidence, none of them, but in any event, the judge looked at the totality of the evidence, all of which was entirely consistent. So there's no basis for interfering with the judge's conclusion that discrimination was arising, both as ethnicity-based discrimination and also nationality discrimination. I want now to turn to whether or not the judge's decision can be impeached on the basis that he found that that discrimination was being caused by the scheme. And we left off yesterday with me asking the court to look at the statement of Mr. Patel and the statement of Mr. Smith, where a comprehensive analysis of how the scheme operates and why it incentivises landlords to seek to sidestep the scheme entirely and simply favour those with British passports is the case. And I hope your lordships have had an opportunity to do that overnight. And the key paragraphs there are 18 to 54 of the statement of Mr. Patel, and effectively the entirety of the statement of Mr. Smith. Now, in the course of looking through that evidence, you will have seen at paragraphs 53 to 54 in Mr. Patel's statement that he addresses the efficacy of the Equality Act 2010 and the fact that what landlords are doing if they seek to sidestep the scheme is likely to be illegal, contrary to that act, and the code itself. And if we just take a brief look at that, and your lordships perhaps very quickly review it, because it's not simply a statement plucked out of thin air. The lack of efficacy is, again, evidenced and founded in the surveys and the evaluations that have been conducted. And most importantly at 54. So the evidence goes to those, that's page 19, those who have read the code and whether it makes a difference to their attitudes. And the answer is it doesn't. And also, the judge had before him the evidence of Polly Neat, who is the chief executive of Shelter, and that's, if you turn on from paragraphs 53 to 54 to pages 55 to 6 of tab A of the bundle. Ms. Neat's statement starts at paragraph 47. And then and that's addressed at paragraph 30.
So, which page is
I'm
that?
so sorry, it's at page 55. You're looking at pages 55 to 66, and if you start at paragraph 30 and go to the whole of that paragraph on page 31. So in our submission, it was perfectly reasonable for the judge to make an inference, based on all that evidence, that the scheme, taken as a whole, creates an impetus, an incentive for landlords to protect themselves from the administrative costs, but more importantly from the risks that the scheme presents to them of potential civil and criminal consequences, in circumstances where, while it is an aspect of the scheme that the government is trying to prevent landlords from doing so, they are not, in fact, choosing to comply with the law, but they are, in fact, acting in accordance with that inherent incentive that is characterised by the scheme.
Looked at in a slightly different way, the directive requires states to impose sanctions on those who facilitate irregular migrants from being able to obtain residence. That's what the directive does. That's what the scheme does. That's what this scheme does. On the basis of your submissions, where things go wrong is not there, because that's what the directive requires. It's the absence of sufficient sanctions against discrimination that's the difficulty. If there were greater sanctions available in practice to avoid discrimination, your submission would then be, well, that's fine, because landlords then, because they act in self-interest, will comply with the scheme.
Can I answer that at two points in response to that? I'm just going to make sure I know what you said. So, firstly, the scheme is not giving effect to the directive in the sense that the directive requires this scheme. So, if we look quickly at this directive, and I'll come back to it on justification, but the directive, the key requirement of the directive is set out in SB 118. Supplementary Bundle 118. So the directive, the FRA, Fundamental Rights of Migrants in an Irregular Situation in the European Union, and there's a comparative report. And at 118 we can see what the directive requires. Under the heading 5.1, access to private accommodation.
Well, we can look at the directive. We've got the directive.
Yeah, we can look at the directive.
It's tab 5 in Authorities Bundle 1.
That's right.
And it's Article 1(1)(b). Each member state shall adopt appropriate sanctions on any person who, for financial gain, intentionally assists a person who is not a national of the member state to reside within the territory of the member state.
Precisely. So what you have to proscribe is the intentional letting for financial gain. Now this does not proscribe the intentional letting. It goes much, much further than that. It's a totally different provision. Quite simply is, this is not proscribing the intentional letting. It is not creating a criminal sanction for intentionally letting to those who do not have a right to rent, and doing so for the purposes of securing financial gain. It is a scheme which potentially criminalises individuals for not taking sufficient reasonable care in the determination of whether somebody does have a right to rent. That is entirely different to intentionally, knowingly, or recklessly doing so. They are very, very...
You use that the legislation has gone wrong by introducing the qualification or has reasonable grounds for the belief.
I'm not submitting it's gone wrong. We don't have any evidence yet that this legislation was introduced to give effect to this directive, point one. There's no evidence at all. But the second point is, it goes further than the directive requires. Now, if you want to say it's gone wrong in doing that, that may be one way to characterise it. The point I'm making is you cannot look to the directive and provide that and use that as a source of justification because the directive does not require this scheme.
Well, no, because this scheme is enforcement, and enforcement's a matter of domestic legislation.
Yes, but what must be enforced is the terms of the directive. If the government chooses to go beyond the terms of the directive and do something more extensive, and if, as a matter of fact, that something more extensive is causing landlords to discriminate, then the directive is not a justification for that, because it's not what the directive requires it to do. The directive requires it to do something which is altogether different. It requires it to prescribe landlords from intentionally, deliberately, knowingly letting to people who are not entitled to be here. And that is an entirely different creature to what this scheme is proscribing.
It may be that the 2016 amendments bringing in criminal liability are perhaps more closely linked to Article 1B. I mean, that is, broadly speaking, doing precisely what 1B seems to require.
In my submission, it isn't, because it remains the case. It remains the case that the 1B catches individuals who do not intend to let to individuals who have no right to rent. And this scheme is exclusively directed at those. It is a criminal sanction which is based upon as many criminal sanctions are, intentionality. That's what distinguishes this situation from a civil situation, where it may be simply as a matter of negligence that an individual has ended up letting to somebody who doesn't have a right to rent. But this is entirely consistent with where the criminal law ordinarily comes into effect, which is in respect of things that are unlawful and done intentionally. And that is what this attacks, and it is an entirely different situation.
But according to Sir James, and my understanding of the scheme is intended to encourage those who do not have leave to enter or leave to remain, either to regularise their immigration status or to leave the United Kingdom. Here, the Member States should adopt appropriate sanctions, that's a matter for them, on any person, that is a landlord, who for financial gain, definitely yes, intentionally assists a person who's not a national of the Member State.
Yes.
That is as I understand it, that is the purpose of the scheme. You may say, well, the scheme doesn't do that, but that's the purpose of the scheme.
So one's confusing their purpose with what must then be done in fulfilment of that purpose. So the purpose of the two is coterminous, but what the directive requires to give effect to that purpose is something that is different from this scheme. It requires states to impose sanctions on those who deliberately do this. The scheme imposes sanctions on those who do not deliberately do
Very
this.
narrow reading of the word intentionally is used in a directive, because it seems surprising that it wouldn't then extend to people who are reckless, simply can't be bothered to check.
Well, it probably
doesn't-
would include people who are reckless, but those people would both offend necessarily against the scheme, but the scheme also, and the legislation, but the scheme catches people who are not reckless.
Well,
The scheme catches people who haven't taken sufficient care, but they can still be caught if they're merely negligent, and that is a fundamentally important distinction. The fact that the scheme and the legislation will catch all people who act intentionally or recklessly does not mean they're coterminous, where the scheme also catches people who act negligently. So they're not coterminous.
So what do you mean by negligently?
Acting without reasonable care. But nonetheless, not acting deliberately, not intending in any sense to act, to let to an individual who does not have the right to rent, but nonetheless failing to carry out proper checks that are required in...
We're hypothesising someone who knows about the scheme. If someone simply can't be bothered to underdo the checks,
Well, it may
Why-
not
surely
be
the
that
scheme's got to catch them.
they simply can't be bothered to do the checks, but they've carried the checks out in a way that is negligent. The critical point is negligence is not intention or subjective recklessness, and it catches those individuals. It simply is not a replication or a giving effect to this scheme. It goes further than is required.
But to go as far as the directive requires, the landlord is going to have to check in some way whether the prospective tenant is or is not a member of a national state. The scheme sets out how that can be done.
Yes. Yes, and I'm not clear what the consequences of that is, as to whether it renders the scheme something that gives effect to the directive.
I just find it very difficult how, if your submissions are correct, how the directive could possibly be implemented anywhere.
Well, you could simply create a criminal offence for intentionally. That's the most obvious way, and some of the countries do that. You create a criminal offence of intentionally letting to an individual who does not have a right to stay.
Just give me a minute.
Straightforward as that. That is prescribed in criminal law, precisely as the directive describes what must be prescribed.
In those, I mean, it depends on the efficacy of the criminal justice system wherever you are, but that might cause discrimination. because what's to prevent a landlord saying, in any country, if you're in Austria, I will only let to a person holding an Austrian passport. That's discrimination.
Well, one would have to look at what the effect was, but the difficulty for anyone seeking to challenge that on the basis it does, as a matter of fact, cause discrimination, and in my submission it would be very unlikely to do because of the specific requirement you have to show intention and deliberateness, as opposed to, I really didn't realise this person was. Maybe I should have done some more checks, but I honestly didn't realise that this person was and didn't intend to let to them on the basis they were an illegal migrant. It would be pretty surprising, given the narrowness of the offence, that people would be put off. But if they were put off, you'd have to look and see and measure the discrimination. But the problem you would then find is that it would be something that would be justified because it's part of the directive.
But on the basis of your submissions, we know that landlords are very risk averse. If they're threatened with criminal prosecution, why don't they, in response to the mystery shoppers, simply go for those who have British passports? That's the obvious thing to do. Well, they know then that they can't.
Why wouldn't they, on the basis of a scheme that criminalised?
They would. We know they would, because that's your submission.
We don't know they would. We do not know they would at all.
Because
in the face of
the greater the sanction, you say, the greater the sanction, the less effective it's going to be.
The sanction is one thing. The offence is another. They have to ask themselves, what is the risk I'm going to be caught by this offence? This offence is framed to catch me only where I act knowingly and deliberately. That is an extremely narrow class, or narrow offence compared to where I act with the best of intentions but negligently, which is what the scheme currently catches. So it would have to be shown that I well knew or didn't care and nonetheless went on to let because I wanted to make a quick buck. Now that is not a substantial risk for any landlord. It simply isn't. Whereas the scheme creates myriad risks for landlords as well as expense and inconvenience. And an example of how the scheme differs. So for example, you've got multiple people who are going to occupy a particular premises and the landlord fails to check all of those, and it's found that he's negligent in failing to check all of those. That is caught by the scheme. It is not, and it would not form the basis of a prosecution for intentionally letting to somebody who does not have a right to rent. They simply are not coterminous, and it doesn't give effect to the scheme. Can I come back then to, we were looking at this in the context of causation and whether or not the scheme is actually causing discrimination. And I had made the submission that the judge was perfectly entitled to rely upon the evidence as to how the scheme, despite the illegality of the conduct and the code of conduct that makes that clear, is incentivising landlords to do that, and his finding that they in fact are acting on that incentive. The government itself, and this is a really important consideration, the government itself recognised this risk. It recognised that the scheme had this quality when it was proposing its introduction and assessing the potential impact of its introduction. So we can see that in the impact assessment in the supplementary bundle at page 140. Your Lordships can, at page 140, read the three headings, starting with disproportionate penalties, and then heavier penalties may provoke, and then UK citizens without ready access to paperwork. If you can read those three paragraphs, and then we'll turn on to page 147.
147.
147, under the heading discrimination. What we see there the government is equally concerned at the bottom of the first paragraph to address the risk that the new checking duty will result in unlawful discrimination. It wants to address that risk. It wants to take that risk out of the equation. But the critical point at the moment is it recognises that that is an aspect of what may be the consequences of the scheme. And then if we go to page 166, you can see this is in the response to the consultation, which starts at 160. Paragraph 101. Again, the government takes any perceived risk that a policy may inadvertently increase discrimination or impact upon equality with the utmost seriousness. It doesn't want that consequence. It's not a cost that it is determining is worth paying for the introduction of this scheme. But for our purposes at the moment, it's the fact that it recognises it. You can see why this scheme may have that effect. And then we have a high proportion of respondents, this is before it's introduced, 55%. Not that far from those who, after the scheme's introduction, said they are actually less willing to rent. Mr. Patel puts the point in this way at paragraph 44 of his witness statement, and I adopt it. If such behaviour, i.e. discrimination on grounds of race and nationality, is found to be occurring, and those engaging in it blame it on the scheme, and the scheme itself encourages it, then it is reasonable to attribute it to the scheme. There is a logic, there is an explanation, there is a ready available set of reasons as to why what has been found to be happening is happening, and that explanation, the critical causal explanation, lies with it is the scheme that is doing this. And perhaps a better way to put it is that the scheme doesn't expressly encourage it because of all the provisions about not discriminating, but it does incentivise it. And where the existing provisions deterring discrimination are not efficacious in this particular context, as we've seen the judge so found, then one is left with the incentive, uninhibited, save by those landlords who are going to say, I'm going to comply with the law, come what may, then the incentive is not constrained by that illegality and individuals are acting on it. And the bottom line is, that is what the surveys and the mystery shopping exercise shows. And the judge was perfectly entitled to draw the conclusions that he did. And one has to stand back and ask, what other explanation is there for the discrimination that has been observed? You can't explain it on the basis that landlords have always preferred passports. That can't explain the discrimination on the basis of ethnicity. What other explanation is there? The government has come up with none because the government is seeking to impeach the finding that there is discrimination at all. But insofar as this court concludes the judge was perfectly entitled so to find, then what's the explanation? And the judge I'm just going to very quickly pass over the judge's analysis, because the judge's analysis in the judgment followed exactly that structure. Is there discrimination on the evidence? If so, what is the cause? And what is the role that has been played by the code of practice and the fact that discrimination is illegal? And 13 to 17 of his judgment, he sets out the entire scheme, including the code of practice. At 70, he gives a short summary of how the scheme incentivises discrimination. At 71, he considers the lack of an effective mechanism to deter.
Well, this is recording submissions.
Yeah, this is recording the way in, yes, he's recording submissions. He refers in some detail to the evidence of the RLA, and in the face of all of that, he then makes his findings. Can I just address two issues that were raised before, in this appeal by the appellant, that weren't raised before the judge in relation to the surveys and the evidence? The first is at 30.1d of the appellant's skeleton argument. That's at CB 24, 4 bundle 24. And here, it's the criticism that the mystery shopping exercises conflated non-responses with outright negative ones, and was neutral in respect of positive ones. And they say that the consequence there was that in reality, or rather not the consequence, but what it might have missed, is that in reality Ramesh might have had more positive responses than Harinder. But of course it really does go both ways, because it is both attributing neutrality to a positive response and negativity to a neutral response. And in any event, a neutral response means that it is much more consistent with a negative response. If you don't get back to somebody, plainly, that's a negative response. And the second matter is that, this is at 32.c on page 26, those responding to the RLA surveys may have been predisposed against the scheme, given the general antipathy of those bodies to the scheme. Now, that was a criticism that was raised in the court below, but only in relation to the RLA's surveys. And so far as the RLA is concerned, its survey went beyond the scope of its members, and that's clear at supplementary bundle page 350 for your lordship's note. Shelter's survey was entirely blind, so nobody would have known that it was Shelter that commissioned the survey, and that is at page 281 of the supplementary bundle, again for your lordship's note. So the second major criticism of the defendant was that if the judge's findings on discrimination and causation are unimpeachable, then he nonetheless erred in respect of the scale of discrimination that he found to have, or to be arising under the scheme. And if we just remind ourselves of what he found at paragraph 60 that some individuals will be unable to find accommodation at all, and some will have been unable to find accommodation for such a long period that their family life has been interfered with. This is at page 72 to 73 in paragraph 60. At its highest, the evidence established. Nevertheless, I'm asked to draw the inference. Your lordships have that at the end of that paragraph. And at 96, he accepted that scale of hardship is enough to cause a real disadvantage to the affected cohorts. So the appellant says that that is not a permissible conclusion for him to have reached. And in our submission, those findings were plainly open to him on the evidence. We looked yesterday at the scale of the problem identified in the surveys. If we just look at the government's own survey of 350,000 landlords, we touched on the sheer numbers who would be affected if 25% of landlords are taking this approach.
Yes, but I do deal with, I think it was being said, there's really an internal contradiction in the reasoning of paragraph 60, because it starts off saying what the evidence at its highest establishes, namely people will find it harder, and then goes on to draw inference that there are actually people who are unable to find any accommodation at all, which seems to go beyond the highest level of the conclusion that's already been reached. And I think that was part of Sir James's criticism, the kind of logical disconnect actually in the judge's own reasoning.
In my submission, that is, the two are not internally contradictory. He's making the finding that it will be harder, and in respect of some individuals, they will not be able to find accommodation at all, or for such a long period as their family life has been interfered with. So there's a general increase in the hardship, but there, for some, it has a more significant impact, making it impossible for some individuals, and for others, the process of finding accommodation is going to be drawn out so long that their family life will be interfered with. So I don't see those as a contradiction.
Well, in any event, I mean, I appreciate it's always easier to pick over individual sentences in a long judgment and be critical. It's the kind of thing we all do sometimes.
Yes.
And one has to read it with a certain degree of
Flexibility, yes.
flexibility.
Yes.
Can I just make sure I've got the statistics right, your submission on the basis of the statistics right? You've said that if your immediately previous submission was that if 25% of landlords taking this approach, then that's sufficient.
It's an enormous number of people. There are 350 landlords on the government's own, 350,000 landlords on the government's own evidence.
I'm sorry.
$350,000.
That's a lot of landlords. It's 100,000 landlords or whatever it is. Where did you get the 25% figure from?
Oh, that's the government's own survey.
Right.
So that's what we looked at yesterday.
Yeah,
it was the evidence we got just before the hearing started last year.
That's 25%.
25%.
I mean, your data broadly say 50%. I mean, I know the figures.
40% or so.
40%.
40%. And taking off, as your lordship said yesterday, those who would positively be more willing to let, it was about 40%, 39%.
Does that mean statistically this? that if I'm a potential tenant and I apply to, at least on the basis of your data, so let's say it's half, it's not quite half, but let's say it's half. Does it mean that on your data, if I apply to a landlord, there's a 50% chance that he will take this line?
Of only letting to people with British passports?
Yes.
Yes. A 40%. But what the reason we have taken the 25% is that even if you go on the government's own figures...
No, sorry, I understand all of that. I understand your point about the sheer numbers, but this isn't actually a numbers game, is it? It's a percentage. We've got to really look at the percentages. Does that mean that the chances are that I will apply to a landlord who does not take this view every 2 attempts?
You will apply to a landlord who takes this view every 2 attempts?
Yes.
So,
but and if that's right, how can one extrapolate from that that a tenant is never going to find a property? I just don't understand them.
So the implications will be that somebody, for example, who is British, BME British, doesn't have a passport, applies to a landlord, and the landlord has a preference for a British passport. And in that case, given the 25% figure, let's work with 25, or if you want 1 in 40, 40%, they are going to, in every 4 cases, in 1 out of 4 cases,
no. 40%, 4 out of 10 cases.
or 25%. If we're doing-
25% is
So the
two,
reason we, the
2
reason
or 3 out of 10 will take this attitude to tenants.
yes,
Only 2 out of 10. I know you say it's a lot of landlords, but doesn't that mean that if I'm a tenant in this minority group, if I make an application to a landlord, the chances are that the landlord will not take that approach because there's a 60% or a 75% chance that he will not. And statistically, if I make 2 applications, the chances are that one of them will not take that approach. I just want some help on the statistics.
yeah, that's what the statistics say, and then as we know, that statistics are just statistics, so you have to then think about what happens in practice. There is a 1 in 4 chance, if we take the 25%, or a 1 in a 40% chance that you're going to have a landlord who takes that approach. Now, it may be that you happen to be very unlucky and you get 4 of those landlords, the 40% risk, who take that approach, and that is going to have an implication for that individual. You can't just slap the statistics on that individual and say in every single case 60% of the landlords are not going to do it. So he will have, say he applies to 10 landlords, 6 cases.
I understand that.
Yes.
That too cuts both ways, statistically, because some prospective tenants will be, in inverted commas, lucky on their first attempt. But do we have any data, any analysis on the statistical probability of a tenant having 4 times in a row a landlord who takes this unfortunate approach?
We don't, and that's why it's therefore a matter of inference. And I took the court yesterday to the inferences that the court is entitled to draw on the basis of the evidence before it, and it was an inference that the judge drew from the evidence that there is. And in our submission, that was an inference he was entitled to draw from the sheer scale of the numbers, the statistics as to how many are likely to do that, and he was entitled then to say, well, of course, some individuals may be subject to this, some may get lucky, but others are going to get unlucky. And that's going to be necessarily the case when something is merely a statistic. It's framed from what actually happens in practice. And in practice, some individuals are going to find that they really are repeatedly ignored, turned away.
So I just, I'm sure of the direction of travel, and I understand the points you're making, but on your argument, is it critical to the judge's findings with regard to ambit that he drew the inference about homelessness?
No,
You said that is not, in fact, a critical step.
it's not a critical step.
So why did the judge say what he did?
Well, there are many cases where findings are made which aren't a necessary part. He's simply concluding
Right.
on the basis of his evidence.
On your argument, you don't actually need, to rely on the judge's inferences to
We
homelessness.
don't need to rely
on the ambit. Right. Sorry,
But your lordship will have seen that one of our arguments, we make a cross appeal, and one of our arguments is that actually, on the basis of this finding, this is a case of interference with Article 8. And it's conceded by the other side that if it's an interference case, then it's within the ambit in any event.
I wasn't talking about your respondent's notice. I was talking about the ambit point.
Yes, but that is an aspect of ambit.
Right.
So that's why.
But you don't say that homelessness is a critical step.
Absolutely, we don't. No. And I will come on to that. But at the moment,
I appreciate you're dealing with causation, but I just wanted to just get
dealing with the impact.
Yep.
And that doesn't stand alone. There was a question yesterday about what would be the implications for an individual who did find themselves repeatedly turned away and unable to find any accommodation. What would the state do to step in? And this is a very, very complicated area, and we will happily provide a note that perhaps the parties could agree if your lordships would want it. But in very short form, the position is this, that if you are subject to immigration control, then legislation prevents you from seeking housing assistance from the state, subject to an exception that the Secretary of State can make, and which the Secretary of State has made in respect of people who have leave to remain, but only insofar as a person has leave to remain and is not subject to, among other things, a condition. The default position is that the Secretary of State does, in respect of people to whom he grants leave to remain, make them subject to a condition, and it is a condition of having no right to public funds. Excluded from that group of individuals who have leave to remain are refugees and persons granted humanitarian protection. So they can secure housing assistance. But unless an application is made and succeeds in respect of those to whom the condition attaches, they will not be able to partake of secure any housing assistance, and they're not entitled to any other welfare benefits.
But in those circumstances, they would be homeless.
Yes, so they'd effectively find themselves in a homeless situation.
Yes, and then the homeless scheme would kick in.
And then, no,
I assume.
No, no.
That's what you're kicked out of.
Yes, it's exactly what you're kicked out of. You are kicked out of that homelessness scheme. That's the point. You have no recourse to public funds whatsoever or to housing assistance. Housing assistance being that provided by the state through the homelessness scheme.
I mean, just speaking for myself, a short note on the position of people who fall outside this scheme would be helpful.
Because when I put the point to Sir James quite early on in the argument, he did rather shortly say you then rely on such benefits available, and you say there are simply none.
So for those who fall outside the scheme, i.e. those against whom the scheme is targeted, illegal migrants, they are in the position that they are subject to immigration control. They don't have leave to be here, and so they are necessarily and automatically excluded from housing assistance. And they can only then bring themselves into any form of assistance when they reach the point of destitution. For those who are not targeted by the scheme...
And presumably though, we are postulating a tenant who can afford to pay rent without recourse to public funds.
But we're dealing with a tenant, we're now looking at the situation where the scheme is not targeted at you, but you're being discriminated against. You're a foreign national and you can't get accommodation. That's the impact of the discrimination. So the fact that you can pay is not helping you. That's what we're dealing with. So the question is,
what's a considerable amount of opposition to this whole scheme, based not on the issues of discrimination that we're arguing about in these proceedings, but on the position of those who are indeed people with no entitlement to be in this country, the people who are designed to be excluded? Was that a considerable part of the opposition to the whole scheme, saying, look, they may have no right to be here, but the fact is many of them are destitute and vulnerable people, and it is monstrous? It was that part of the general opposition to this scheme? That's right.
so there was a moral argument, but actually in practice the focus was on the unintended consequences.
The indirect,
on those.
so that has always been the focus, because not infrequent, as you know, in at least in judicial review cases, very often the courts are concerned with the process by which a decision is reached, whereas the fundamental reality is that people just don't like the decision itself. But that's not the way the courts can approach it under judicial review. And I was just wondering whether there was any element of that in this case, that the true target, or one of the targets, is the very people who have no right to remain in this country, simply being left destitute and homeless.
Well, that is absolutely not the target of this litigation.
I just wanted to, that's very helpful.
This litigation is about race discrimination.
I appreciate
against
that, but I just wondered whether there had been at the earlier stages of these surveys the other agenda, namely the very people who are going to be told you can't have accommodation, which is a valid point. And
Well,
you
of
can
course,
agree with it, you can disagree with it.
there will
It's a
be
valid
many who
point.
will take a moral position on
Yeah.
that, but the focus of this challenge and
Right.
a key part of the
okay.
concerns expressed in the consultation, in the course of the consultation,
With the indirect discrimination.
about the discrimination
Well, that's very helpful.
that wasn't intended.
The note I think were very helpful, but there's a link in this way, isn't there? Because the individuals who you are concerned with, who are individuals who have the right to be in the United Kingdom but can't get accommodation because of the discrimination which you identify, they are left without accommodation.
Yes, so this is part of the explanation. So I've just described that those...
No. Just let me finish the question. They are then put, aren't they, into a similar position to those who have no right to be here. I mean,
That's exactly the point.
No.
That is precisely the point. They then...
But that's why the position of people, so far as accommodation is concerned, who have no right to be here, is relevant to that extent, because the people you're most concerned with, as I understand it, will effectively be in the same position as them, although they do have the right to be here.
So there is one difference. So that those against whom the scheme is targeted, if they voluntarily leave, i.e. if the scheme does what it's supposed to do, and they decide they're going to leave because the environment has become so hostile, then they will be accommodated until they do. But for those against whom the scheme is not targeted, but they are the sidewind of the scheme, they are affected in the way that we are complaining about, there is no such.
No, that's a good point. I understand that. But what happens to people who you are interested in? That is, people with a right to live here, but who do not get accommodation because of the discrimination. What happens to them in practice is relevant, at least to justification, for example. I would quite like to know what happens. Where do people go who do not get accommodation because of the discrimination you have identified? People have the right to be here, they can't get accommodation because of the discrimination. Where do they go?
Well, they're going to have to do things like sofa surf, if they can find somewhere, some friends who'll put them up for a little bit of time and constantly be on the move until they can find somewhere that's secure for them to settle. They can't go to the state to say, provide me with some temporary accommodation. That is the point. They are in exactly the same boat. If they are a foreign national who has leave subject to a condition which is the default position, they are in the same position as those who are irregular migrants.
Anyway, I think all three of us, if in due course someone could prepare a note on what benefits, if any, and it'd be, it's going to be very preferable this could be an agreed note.
Yes.
Rather than competing, hopefully Junior Council can agree what the consequences of law are. Thank you.
I'm sure that's possible. So that concludes causation.
Yeah.
But
your short point is these were findings that were open to the judge. And
unimpeachable.
Sir James is not shilly-shallied about the usual standards that apply on an appellate approach.
Yes.
Yeah.
Comes nowhere near engaging those standards, we submit. Can I then turn to state responsibility? So, working on the assumption the judge was entitled to find that this scheme is causing the discrimination in the sense in which he found it, that is, that this would not have happened but for the scheme. That's at 105, we looked at that yesterday. Then is the state responsible for that discrimination? And I start simply by observing that it would be very surprising, and by responsible, we mean is it under a duty to justify it, to explain it, to show that it is proportionate. And I start by standing back and saying, simply, it would be very, very surprising if an instrument which is intended to ensure the enjoyment of rights without discrimination should not require the state to justify discrimination in the enjoyment of those rights where it has, by its very own act, caused the discrimination to occur. Not given an individual an opportunity who is inherently racist to discriminate, but actually led that person to do something which is discriminatory when they would never have done so otherwise. And if the state isn't responsible, it will contain such an obvious weakness by allowing states to sidestep its guarantees through the manipulation of private citizens that it simply wouldn't be effective in delivering the rights that it guarantees. And we know that one of the key principles underlying the application of the Convention is that its rights are real and effective and not theoretical and illusory. And that is absolutely at the heart of the Convention. In our submission, that is not the approach that the Convention takes. It's not an approach that is compatible with the entire scheme of the Convention or with the application of Article 14. And I'd like to start with the scheme as the Convention, because we want to, what one would expect is consistency in the way this scheme is applied. Can we start by just looking at the language of Article 14? That is in Bundle 1, and it's in the schedule. It says page 4 to 5, I think. 4 out of 5, rather. The enjoyment, the enjoyments of the rights and freedoms set forth in this convention shall be secured without discrimination on any ground such as, shall be secured, the enjoyment. If we then move on to Article 1, which isn't part of the Human Rights Act, and so we have it in tab 6. This important provision, important because it's been used repeatedly in interpreting the substantive rights, provides the high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms. So we have that duty to secure the enjoyment of the right or the right. Now, there are numerous instances where, although the Convention is an instrument that imposes obligations on states, not private citizens, the court in Strasbourg has found that the state bears responsibility for the conduct of its citizens. Numerous instances where the conduct of that citizen either is contrary to what is prescribed by one of the substantive rights, or risks being contrary to one of the substantive rights. So by way of example, where a private citizen is at real and immediate risk of being attacked in a way that is inconsistent with the rights guaranteed under Article 3, freedom from torture, inhuman and degrading treatment. So where a private citizen is at real and immediate risk of that sort of treatment by another private citizen, the state comes under an obligation not to pass laws, but to actually take operational measures to avert that risk. It has a responsibility for that conduct. Or where that risk has been realised, where that individual has actually attacked a private citizen in a way that is serious, such as by rape, for example, then the state has a responsibility in respect of that attack. It must subject it to criminal sanction. It has to pass laws to prescribe that conduct, such as our Equality Act does in relation to discrimination. It secures the enjoyment of that right by prescribing it through laws, by prescribing discrimination through laws. And not only must it criminalise that conduct, it has to conduct an effective investigation into a credible allegation that a private individual has seriously assaulted somebody, raped somebody, contravened the prohibition in Article 3. Those are all cases of state responsibility. And the case that I've just described of the state having to conduct a criminal investigation, that was considered by our Supreme Court in the case of DSD last year, DSD and the Commissioner of Police for the Metropolis. It's not in the bundle, but we do have cases that are in the bundle that make this point. So Z in the UK, tab 57. Z in the UK was concerned with children who had been horrendously neglected by their parents. So the neglect, and if one looks at page 70, paragraph 73 in this judgment, so the neglect to which they've been subject.
Sorry, which tab are we at?
It's tab 57,
57.
paragraph 73. So it's a case of terrible neglect, and the case against the state was its failure to protect those individuals when there was a real and immediate risk of serious ill treatment that the state ought to have been aware of. And at 73, we can see the responsibility of the state being engaged in respect to the conduct of those individuals.
Sorry, paragraph 73.
73.
This is an Article 3 case.
Yes, it's an Article 3 case. So I'm looking here at the scheme of the whole convention and how it looks at state responsibility for the acts of private individuals and provides many, many instances where it is responsible, where it itself, and this is a very important point, its own conduct, it hasn't contributed to that risk at all. That risk is entirely independent of any failings on the part of the state, but it nonetheless has to take action. It is responsible for preventing that conduct. If you read that paragraph, and then if we look at Rantsev and Cyprus, that's tab 69.
Tab 69.
No, it's not tab 69, 66, I'm sorry. And if we turn to paragraphs 283 to 289, you'll see this is in the context of trafficking. A woman who was trafficked from Russia to Cyprus and eventually died there. And it's all about the state's responsibilities to protect private citizens from trafficking by other private citizens. And we can see a whole series of obligations carved out under Article 3 on the part of the state, duty to implement laws prescribing trafficking, an operational duty to protect, as in the Z and UK case, where there's a foreseeable risk of non-state actors trafficking an individual, and then a duty to investigate that I described, the criminal investigative obligation.
In this case, there was an Article 8 claim that was found not to be admissible. Is that relevant?
No, it's of no relevance. This is simply to address instances where the state is under a positive obligation because it has responsibility for the actions of private citizens. So it's 283 to 288. And then there's a case of Costello-Roberts, which Sir James took your lordships to yesterday and sought to distinguish. That's A53. And this is all about corporal punishment by a private actor, i.e. the head teacher in an independent school, and the applicant was subjected to corporal punishment and sought to hold the state responsible for the conduct of the private actor. In circumstances where it's absolutely clear, of course, the state itself had not caused that, it was not complicit in the fact that the headmaster chose to administer corporal punishment. And then if we get to 28, accordingly, paragraph 28, in the present case, which relates to the particular domain of school discipline, the treatment complained of, although it was the act of a headmaster of an independent school, is nonetheless such as may engage the responsibility of the United Kingdom. So here, the engagement of the responsibility of the United Kingdom is such that it's then required to take some steps to address this conduct by a private citizen. It has to pass some laws. In our context, what the state has to do, because of its responsibility for the acts of private citizens, is to justify the conduct. So the simple submission here is that there is nothing inconsistent with the scheme of the Convention to require a state to take responsibility for the acts of private citizens. This is entirely in accordance with that scheme.
I'm not quite clear whether you're trying to equate taking responsibility with justification. I mean, it sounded for a moment as though you were saying the obligation on the state was to justify, which of course it is, but that's the justification issue. But I don't
I'm so sorry, my lord. We, in order to get to a position where the state can be required to justify,
Yes.
we have to show that the state is responsible as a matter of Strasbourg principles. That is, that this is conduct, albeit by a third party, for which the state bears responsibility under the Convention, and which therefore obliges it to justify that conduct. So I'm not at the moment saying that responsibility means you can't justify. I'm taking a much more a preliminary step to that.
Sorry, you're taking it step by step. I understand that.
Taking it step by step.
Are any of the cases you've got on this step, Article 8 cases, all of the cases you've referred to are Article 3?
Oh, I mean, I haven't got a case. MC in Bulgaria. MC in Bulgaria is a case in which it was brought both under Article 3 and Article 8, because Article 8, of course, contains within it the words duty to secure the enjoyment of the right, so it already contains that positive obligation on the state. But MC in Bulgaria is a case where an individual was raped, and she brought her claim both under Article, raped by a private citizen, and she brought her claim both under Article 3 and under Article 8.
Have we got MC?
I'm afraid we don't. We can get that from the court. But they applied exactly the same analysis, that there is that obligation under Article 8. But what they did is they analysed it under Article 3, because that was the more serious, and of course if it succeeded under Article 3, they didn't need to go on separately to analyse it under Article 8, but they made clear the duty to conduct an effective investigation into that rape arose both under Article 3 and 8. And ZUK as well.
What, is it the ZUK at tab 57?
Tab 57. Perhaps Mr. Burton can find the relevant paragraph.
I mean, Z is an Article 3 case.
Yes, but
What
they also...
What they said was, having dealt with Article 3, is often said, you don't have to think about it.
Don't have to think about it. Yeah.
But that's not the same as...
No. MC in Bulgaria
Yes.
unquestionably addresses this point.
Thank you.
Yes.
So I'm sure it's my fault, but which aspect of Sir James's argument are your present propositions relating to? To ambit or to
No. So
justification?
yesterday, Sir James slightly dealt together with both ambit and justification. He didn't clearly separate the two out. It's very much separated out in the skeleton argument, the opponent's skeleton argument. And part of their appeal is that the state does not bear responsibility for the acts of private citizens. In other words, it is not necessary to justify it, because this is something which the Convention simply doesn't speak to. That is their position. So I must engage with that argument, and the judge did engage with that argument because it was a massive, one of many points under Article 14 that were run in the court below and have been appealed now. So while Sir James didn't deal with it clearly, it is part of the appellant's skeleton argument, and I need to address it.
Again, speaking for myself, I would like to see at some point MC in Bulgaria.
Yes, I'll make sure that you have that. Can I simply make this point in response to that? We are not looking at the moment at Article 8, we are looking at Article 14 and whether or not the state is responsible to justify the discrimination under Article 14. And that's where you get the language of the duty to secure the enjoyment. It's in Article 14. So I'm relying upon these cases because of their because they are cases that concern the scheme of the Convention in respect of state responsibility where it is under a duty to secure the rights. And Article 14, like Article 1, imposes a duty to secure the right. So, of course, my lord, we will give you MC in Bulgaria, but actually the key point is 14. So, so the question is turning to Article 14, that's the scheme. State can be responsible, is responsible, left, right and centre under the Convention for the acts of third parties, even where it hasn't done anything at all to cause the third party to act in a way that is inconsistent with the rights. Turning back to our situation, we are dealing with a case not where the state hasn't done anything at all to cause third parties to act inconsistently. We are dealing with a case where, on the judge's findings, it is the state's activities which are causing third parties to act inconsistently. In that sense, the situation is no different than from where the government legislates, for example, in respect of the conduct of private citizens in a way that is going to necessarily entail discrimination. So, for example, succession rules that discriminately impact upon unmarried couples or discriminately impact upon individuals by reasons of their sexual orientation and so forth. So that's where we are, and there's no question in relation to those cases where the legislation requires individuals to then behave in a way that is discriminatory, i.e. Then the state is responsible. Article 14 jurisprudence itself is entirely consistent in our submission with that approach to state responsibility. The approach being that the state is responsible not only, but certainly where its conduct actually causes the discrimination in the sense that it wouldn't have happened but for, but it's responsible also in cases where the effect of its conduct is that discrimination arises. And all that Article 14 is concerned with is to look at that causal connection, cause and effect. And that's clear from the case...
In the Costello-Roberts case, what was the cause and effect?
So that's not a Article 14 case.
No, I know it isn't.
So
but
there, the responsibility of the state, and we go back to paragraph 23, and the court says in terms the state is responsible to do something about that conduct. So it didn't cause it, but it's responsible to do something about it, i.e. to prevent it, by passing laws. But the significance of the case is because it demonstrates that the Convention does hold states responsible for the conduct of private persons.
Anyway, you would say you're a fortiori.
Well, we're...
The judge's findings, you would say you're a fortiori. You would say there's a direct relationship between the scheme and the conduct in question.
There's a direct
And the
relationship,
scheme was passed by the state. So
and the scheme was passed by the state,
You,
and
you really, I think you could say you're A40 all right to some of these cases.
we do say that, but the defendant's position is that if you actually look at the Strasbourg jurisprudence on Article 14, there are no cases whatsoever that support the view that the state could be held responsible for the acts of private parties. And they criticise the cases we've relied upon on the basis that those cases were ones where the discriminators, those who were actually giving effect to the scheme and discriminating, were all state agents, and therefore they
Well, the
say...
bigger question is, can the state be responsible for the acts of private parties when the measure in question is specifically designed to prevent that conduct?
In our submission, that's justification.
Well, it may be so, but that actually is the bigger question, isn't it?
Well, in my submission, that is a question that is only relevant to justification because
That may be right.
because responsibility
That may be right.
focuses on cause and effect. That's the position, and that is what the Strasbourg jurisprudence supports. And then you look at whether the measures they've taken to prevent this are sufficient
Well,
to
you'll
justify.
come on to that.
Yes, but I want to deal specifically with causation, and that being the test under Article 14, because in our submission, the case law, albeit it doesn't touch directly upon private persons, the court's jurisprudence shows that it isn't bothered whether it's a private actor or a state actor that's doing the discriminating. It's looking at the effect of the scheme to see, does it produce discrimination? And it's also not concerned with the mechanism, it's just looking at cause and effect. And then justification is the time at which you begin to look, how has this come about, what's been done to try and prevent it, and so forth.
Well,
So,
you're going to produce MC by going to court. Is there anything else you wish to say on state responsibility?
yes, I want to look at the cases.
Right. Okay.
I want to turn to DH,
Right.
and A63, Authorities 63. So, we looked at this, I think, briefly yesterday. This was the Roma children being educated
Yes.
in special schools, even though they didn't have any special needs in the sense that they were learning disabled, but that's where they were placed as a result of the government scheme and how it was applied in practice, which involved psychometric tests being applied, psychological tests being applied, assessment by psychologists and so forth. And we saw that there is a very, very substantial discrimination in terms of the proportions who found themselves in special schools as compared to the general population. If your lordships turn to paragraph 175, so the court has established in its case law that discrimination means treating differently without an objective and reasonable justification persons in a relevantly similar situations. However, Article 14 does not prohibit a member state from treating groups differently in order to correct factual inequalities between them. Indeed, in certain circumstances, a failure to attempt to correct inequality may give rise to a breach. The court has also accepted, and this was cited by the judge, this part, that a general policy or measure that has disproportionately prejudicial effects on a particular group may be considered discriminatory, notwithstanding that it is not specifically aimed at that group. And that discrimination potentially, contrary to the convention, may result from a de facto situation. So the question is, what as a matter of fact is happening? What are the effects, the causal consequences of the measure? And one simply looks at the facts. And then we go to, if you'll just read also there, 176, my lords.
Well, I read that and I read 177.
So we can see that that paragraph 176, in a sense, bolsters what's there at 175 in respect of racial discrimination. This is particularly invidious, and states are under a duty to use all available means to combat it. Now, if they're under a duty to use all available means to combat it, then it must unquestionably follow that where their action is causing it, they must be responsible to account for that. They can't simply absolve themselves of responsibility. And also the observation, if discrimination is based to a decisive extent on racism, then it's not going to be justifiable. That is how strongly the Convention protects against race discrimination. And yet again, if one works from that premise, it is absurd to suggest that the government is not required to justify discrimination on grounds of race that it is causing itself. And 175 supports the proposition that it must justify it because it is an effect, and it's the effect that must be justified. 185 It was common ground that the impugned difference in treatment did not result from the wording of the statutory provisions on placements in special schools that caused the material time. Accordingly, the issue in the instant case is whether the manner in which the legislation was applied in practice resulted in a disproportionate number of Roma children being placed in special schools without justification, and whether such children were thereby placed at a significant disadvantage. Again, the focus, it's an entirely general statement, the focus is simply on what was the consequence when these measures were applied in practice. It doesn't concern itself with who is applying them. It doesn't say it's only if those who are applying those measures are state agents that the government responsibility can be engaged. And there's no reason in principle why it cannot be applied where the individuals that are giving effect to the measure are private individuals, consistent with the scheme of the Convention, consistent with the duty to secure the rights, consistent with the duty on the state to do everything in its power to prevent racism. And then, if in your Lordship's time, you would look at the analysis of the court, if I can just put this for your Lordship's note, (190) to 193, in order to found the discrimination, they look at nothing more than statistics showing the entirely disproportionate way in which this measure is being applied in practice. That is all they look at. And after that, they move to justification. And that's 195, they say, having found, looking just at the statistics, that there is discrimination, the burden of proof must therefore shift to the government, which must now show that the difference in the impact of the legislation was the result of objective factors unrelated to ethnic origin. And the second case I want to take your Lordships to, which is to the same effect, is Zelek and Poland, which is at Authorities Bundle 6, tab 68. You can glean what the complaint is about at paragraphs 81 to 82. And then, can I ask you to look back at paragraph 66 to see what the applicant was actually complaining about, because it's echoed in the court's findings, and that's important. The third applicant maintained that that freedom was very important to him and that he had fought hard for it. So it's the freedom not to identify his personal religious beliefs. The price he paid was humiliation, social ostracism, being forced to change schools and being subjected to physical violence, i.e., that is, prices he paid by private actors. These examples of suffering show that the third applicant had been personally stigmatised. So all that behaviour meted out by private actors, it doesn't say it's the state, it doesn't say his teachers beat him up. And then if we go down to the court's findings at 95, and if your lordships can just read that paragraph. So 96 is a point picked up by the appellant, and what the court notes here is that actually, since the complaint, there has been an introduction of another measure which is going to make the impact even more adverse, because you have to have your marks are affected by whether you've done ethics or religious education, and that's a point which the appellant relies upon as saying, well, this is, decided on the basis of that adverse impact, which was something meted out by the state. But if you look down at 99, and the court does make reference to it, having regard to the foregoing, the court finds that in the absence of a mark for religion or ethics on the third applicant's school certificate, throughout the entire period of his schooling, amounted to a form of unwarranted stigmatisation of the third party. So it uses that word, stigmatisation, going right back to what his complaint was about stigmatisation.
Yes, I noted in paragraph 100, the court went on to say that the margin of appreciation state was exceeded as the very essence of the right not to manifest his religion under Article 9 was infringed.
Yes.
So it's clear that margin appreciation had a part to play, and what tipped it against the state here was that the very essence of the Article 9 right was infringed.
Yes, but the issue here that we're looking at this for is not margin of appreciation. It is,
No, I'm looking ahead again, I'm afraid.
Yes, well, perhaps we can come back to it later, but we are looking at the moment whether the state is responsible.
No, you're
the acts of
quite
third
right,
parties.
I'm sorry, but I'm looking at paragraph 100 for perhaps a different purpose.
Yes.
Right.
So, and there's all the case law on margin of appreciation doesn't apply here, but you may give some deference, and we'll come to that. So it's another case that again provides support for the question being one of effect, irrespective of who is affected. But it is the effect gives rise to discrimination, and it doesn't matter who it is. So can we then turn from there to the defendant's criticisms, not put before the court yesterday, but in the defendant's skeleton, appellant's skeleton. Firstly, a lack of sufficient nexus, the defendant says, this is paragraph 11 of their original skeleton, between the discrimination and the state's actions, and they appeal here to the fact that Parliament hasn't authorised the discrimination. And in my submission, that simply gets the appellant nowhere, where the issue is one of cause and effect, and where in this case we're not concerned with the measure giving racist landlords an opportunity to be racist. We are concerned with a situation where it is the very, very scheme itself which is producing the discrimination on the part of landlords. To say that there isn't sufficient nexus when it is a direct and immediate cause is fanciful in our submission. Next, the defendant says that there are safeguards, and this is all obviously a question that has significance and relevance for the court to consider, but not at this stage. The question at this stage is cause and effect. The question of what bearing safeguards have is for the justification stage. The defendant also relied on the case of Roberts and the Commissioner. And the reason it relied upon Roberts and the Commissioner's case is because that was a case also about safeguards. And we looked at it briefly yesterday, but we're going to come back to it now. Authorities 28. So this was the stop and search powers on the part of police officers, where there is no condition of reasonable suspicion. They are empowered to stop and search without cause. And the issue there was whether or not the safeguards in place were such as to render the provision consistent with the convention. Now, the important point, starting point, is that this is a provision concerned with whether or not the legislation was in accordance with law, not whether or not justification was justified under Article 14, or whether or not state responsibility was engaged for that discrimination. Far less. It's totally unconcerned with that. But if one looks at paragraphs 2 to 3, we can see what the concerns were, or what the issues were in relation to this case. If you read all of paragraph 2 and then paragraph 3 from just above F, the argument is about whether it is in accordance with law. So if you read down to G there, you'll see that the essence of the case was whether or not there was compliance with the need for sufficiently accessible and foreseeable safeguards, the need for it to be sufficiently accessible and foreseeable, which translates into whether or not there are sufficient safeguards against the risk that it will be used in an arbitrary and discriminatory manner. So, no doubt, Sir James has appealed to this case because there is reference to safeguards against against discriminatory application of the power to stop and search. And the court's, the first point I'd make is, insofar as this is relevant at all, it's relevant to justification and not at all to state responsibility. But if we actually look then at why this was found to be in accordance with law, not justified in respect of Article 8, but in accordance with law for the purposes of Article 8, we would need to look down at 41 to 3 for the safeguards that existed. So law for those purposes of structuring the exercise of the discretion to stop and search, to render it foreseeable and not arbitrary and discriminatory, includes a panoply of policy and guidance and so forth. Crucially, at 44 to 46, they address whether and why, given the nature of this exercise and the safeguards that exist, it will actually be possible in most cases to assess whether any individual has been subjected to discrimination. So not only are you provided with a whole set of measures that are going to circumscribe the exercise of that discretion to ensure that it's not discriminatory, but also the nature of the scheme taken as a whole is such that you're likely to detect discrimination as and when it occurs. And so then at 47, the conclusion is reached that it's not the law that is going to be to blame for discrimination in every discrimination by individual officers, i.e. that scheme carries with it sufficient safeguards, but you can't be watertight. There are some racist officers who are going to continue to abuse the scheme. That is a totally different situation to the one we are dealing with, because we're not talking about a scheme that is trying to, or has within it safeguards to prevent racist landlords from being racist. It can't do that. We know that. There will always be racist landlords. We are talking about a scheme that is positively incentivising and actually causing landlords to discriminate. And that's something we'll come back to on justification and something we'll come back to on declaration of incompatibility. But the point for present purposes is this case is nothing to do...
You say which positively incentivises, and did I understand you say and authorises?
No, not authorises.
You didn't say that.
I'm so sorry. Did I say authorises? No, it does not authorise.
Which positively incentivises?
Incentivises. But the point for present purposes is this case has nothing to do with state responsibility, insofar as it has any bearing at all. It's on justification, but actually it's about in accordance with law, so why look at it when it's concerned with a different aspect of the convention? So that reliance on that case is, in our submission, unfounded. On Roma rights, which the judge placed reliance at paragraph 106 in the core bundle, 106 of his judgment at page 90, at the bottom of the page, he cites from Lady Hell's judgment in Roma rights at 97 to 98.
So which tab?
This is in the core bundle, and it's at page 92 in the core bundle. I'm so sorry, it's page 90 in the core bundle. Goes over to page 91. So if your lordships look at that quote, it's true in that case, as the appellant points out, that those who were doing the discriminating under the scheme in giving effect to the scheme were immigration officers. They were state actors. And the appellant also talks of there being an authorisation from above for them to do so, but that authorisation wasn't intended to apply. But in any event, what Mr. Justice Spencer takes from that passage is its essence. The scheme doesn't itself compel the discrimination, but it's wholly unsurprising that its application would result in discrimination. And that's what he takes from it. It's the cause and effect, and in our submission he was entirely and perfectly entitled to do so. In the appellant's supplementary skeleton at paragraph 9, there is a complaint that on the analysis of the judge, the implication would be that the Equality Act itself could be unlawful. If we turn to how this is put, paragraph 9 of the supplementary skeleton. So this is as a result of our concession that the state would have to be regarded as responsible under the Convention for sex discrimination, responsible in the sense it would have to justify and account for, carried out by an individual employer who reacts unlawfully to the creation of improved statutory maternity rights for women. So yesterday we dealt with a more extreme example of that in the question my lord Lord Justice Davis put to me, the implication of the submission is that the Equality Act could itself potentially violate Article 14 in that scenario unless the state could show at the justification stage with empirical evidence that the legislation had succeeded in eradicating far more discrimination than it had caused. But this analysis cannot be right. Well, in my submission, in an extreme case, the analysis could absolutely be right. If in trying to remedy discrimination, the state actually causes far more discrimination, of course it's going to have to try and justify that outcome, which is precisely not the outcome which was intended. The whole purpose of introducing the scheme is not to, or to reduce discrimination. And then finally, the appellant says at the bottom of 9, that yes, in what immediately follows on, where what is challenged is the legality of the legislation itself, the legislation must be capable of being seen to be compatible or non-compatible with human rights at the moment of its creation and by reference to its content. Well, why? The question is, what is the effect of the legislation when a scheme which it creates is applied in practice? There is no principled basis upon which the appellant can assert that you must judge the legislation at the moment of its creation. It's a...
That's right, but leads to the rather curious seeming position that the legality or otherwise of a primary legislation couldn't be in a kind of state of limbo depending upon when the question is asked. And I find that a very difficult idea to get my head around. Surely you have to look at it at the time when it's introduced. I mean, otherwise you have a kind of perpetually changing battleground.
Well, where the discriminatory effects of the legislation are ones that can only be felt and will only be felt on its application in practice, that is necessarily what follows.
Well,
and
for purposes of gaining evidence and so on, you have to look at, have to wait and see how it pans out. But what you're looking at always, surely, is the legislation as of the date when it was introduced.
no, one's looking at the legislation as it applies in practice, and there's no reason why in principle you don't. So from Strasbourg's point of view, they're not concerned with how the measure is implemented by the state. They are concerned with a measure and its effects. And Strasbourg looks at the measure and its application in practice. Our courts look at the measure and its application in practice. That's what they did in Roma Rights. Now, if that measure had been put in legislation, as opposed to through some rules, the logic of your Lordship's position would be that because it's put in legislation, you simply cannot look at how it operates in practice to judge whether it complies with the Convention. And that is to denude the Convention of much of its protection. And if a piece of legislation is intended to give effect to our obligations under the Convention, as the Human Rights Act is, then it would be completely improper to restrict challenges to a piece of legislation to that legislation on its face, as opposed to where the very nature of the legislation creates a scheme which is intended to operate on the ground, as opposed to looking at how it actually operates.
Okay, well, I see the force of that. But I mean, if you are looking at it in a, over a period of time, then you also, this may be more a point that arises in relation to justification, you also have to make allowance for the fact that legislation which is designed and intended to change the way in which people act and carry out everyday activities in an important area of law. I mean, we don't live in a magical world where people's behaviour changes overnight. One must allow a reasonable period for legislation to bed in and for people to be allowed to adjust to it and change their behaviour, and indeed for the state to take a watching brief and see how it's working out and make adjustments if necessary. So, I mean, essentially, you can't have it both ways. If you are looking at the situation as it develops from time to time, you must also make very full allowance for all the difficulties which are inherent in introducing important new social legislation of this nature.
Yes, and so it was first introduced in February 2014, and the surveys were conducted repeatedly over that period, and the mystery shopping exercise was conducted in 2017, so there were long periods for it to bed in. And in our submission, the periods of bedding in was sufficient to see how people were reacting to that scheme. And what's notable is that there wasn't any change over time. So, but I do accept that, obviously, testing it the very next day, or before there has been a proper opportunity to bed in, may require that one has to revisit it. Of course, one of our complaints, this is our fallback position, and we'll come back to it, is that the government itself has done nothing to retest this legislation and see how it's bedding in. But that's something to which we will come at a later stage. October 2014 is when it came into
Yes,
effect.
just so that we're clear, I just want to be quite clear. When are you intending to finish your entire argument?
Well,
We're not giving you leave to be as long as you like, I'm afraid.
No,
And we need you to move on. So just as long as you know, when are you going to finish your entire argument?
well, so what happened
I
between...
thought the timetable was such that you were going to be finishing during the course of this afternoon.
I am.
You will?
Yes.
All right, just...
Yes, I am.
You are, good.
I promise.
Can I write that down in my book?
You can.
All right.
So that's our answer on state responsibility. Just one small point, which is dealt with in our skeleton and was dealt with in the court below, which is that if the court concludes that Strasbourg has not yet gone this far and this doesn't fit into the Strasbourg scheme, then in our submission, this court is obliged to apply Strasbourg principles to a new situation. And in our submission, those principles are clear and they require this court to find that the state is responsible to account and justify, to account for and justify discrimination which it has caused in the but-for sense. And for your lordship's pen, we address that in our skeleton at the key case is KU, authorities 27. If I can give your lordship's pen the passages to read, 2, 3, 3 to 5 of the judgment of Lord Kerr.
This is tab 30.
Tab 27.
27. Say it again. Give the reference again, sorry.
Lord Kerr, 233 to 5, 235, and Lady Hale at 291. And in our original skeleton, we dealt with this, so the point we raised before the judge, at paragraph 125, page 183 of the core bundle. So can I come on now to ambit?
Yeah.
So again, we have to go back to what findings the judge made, and he made at the very least a finding that some people would find it harder to get accommodation, and in fact went beyond that. Some people will be unable
Unable to, yes.
at all, or for such a long time that their family life is interfered with. So approaching it on two bases. Firstly, that he's entitled to make the findings. Well, secondly, that he wasn't entitled to go so far. We would submit he was still entitled to find that some people find it harder to find accommodation. Now, on either of those bases, we submit the judge's conclusion that the measure caused discrimination which fell within the ambit of Article 14 was correct, was one he was entitled to reach.
But by harder, and the judge explained himself, you mean take longer?
It's going to take longer and could take significantly longer. Yeah. And he treated it as a negative modality case, and we're going to address why he was correct to do so. Can I start on ambit by going all the way back to the beginning? I'm not going to take your lordships to that many cases, but I want to go really far back, because in my submission, the further back we go, the clearer it is that this case falls entirely within any notion of ambit that the Strasbourg court has ever had. Could we look first at the authority at tab 50 of the National Union of the Belgian Police, And if your lordships will read,
That's volume 2.
yeah, yes, I'm afraid I don't know quite which your volumes are. Tab 50.
Right at the end. Yeah.
And if your lordships turn to the head note, legislation in Belgium provided for state consultation with trade unions designated as most representative on proposals concerning the status and working conditions of employees in the public sector. A royal decree specified that only those organisations which were open to all staff employed by the provinces and municipalities and which were protected and which protected such staff's occupational interests were to be deemed most representative. And the applicant union, a category-based organisation representing only members in the municipal police, requested the government to include it in that designated category. That request was rejected. And then, if your lordships read the holding held and that first paragraph before you get to number 1. And then,
Yes.
if you go down to C on the next page, and read C down to E. Now, the first point about C is, what the court is there identifying at C is that the Article 11 right itself includes within it, this is an aspect of the core right, a trade union's right to be heard. So that translates into a positive duty on the state to allow it to be heard. So it's a core part of Article 11. And then D, Article 11 left each state a free choice of the means for ensuring that a trade union be heard, consultation being only one of the means. So there are different modalities by which that right can be respected by the state. There are different modalities by which the state can discharge its duty. So at C, considering that the applicant could make representations and put claims to the government, the fact that it was not consulted by the minister did not constitute a breach of Article 11.1 taken on its own. So no breach of Article 11. Unsurprisingly, because it could still be heard. In fact, where's the interference with Article 11? Where's the harm? Article 14 then, paragraph 2, Article 14A was complementary to the other normative provisions of the Convention and Protocols. It safeguarded individuals or groups of individuals placed in comparable situations from all discrimination in the enjoyment of the rights and freedoms set forth in the provisions. A measure which in itself was in conformity with the requirements of Article 14, enshrining the right or freedom in question, might therefore infringe the article when read in conjunction with Article 14, which was pertinent in the present case. If we turn to 40, and we then see that they go on to consider this as an Article 14 case. And if you look at paragraphs 44 to 45,
Paragraph 44.
44 to 45, if your lordships will read those. That's on page 592.
Yes.
So, this is where we find the expression one of the modalities actually emerging. It's in this very, very early case from 1975. But this is a case, and we discussed this yesterday briefly, this is a case where the modality is with respect to the discharge by the state of its duty imposed under Article 8 itself. So it is under a positive obligation to do something, part of the core right, and it can choose how it does it. It's chosen how it does it in this case, and the applicant wasn't included, so the applicant obviously experiences a disadvantage in respect of not being included, but there is no interference with the right to be able to be consulted because that right is guaranteed by another modality. So there's literally no prejudice in the enjoyment of the Article 8 right that arises from this particular measure that the individual complains about. And that is sufficient to bring it in Article 14, just simply because it touches upon one of the core rights.
I'm afraid I simply don't understand that.
So, we have...
I don't know this case very well, it has to be said, but what this says in paragraph 44 it is that there is a margin of appreciation in how this particular right is implemented by the state.
In 44...
Yes, in the last paragraph of that paragraph.
Absolutely, that's talking about Article 11. So it's saying, for Article 11 purposes, starting point, the state is under a duty, under Article 11, to respect the right of an individual to be heard, because that is a core element of the rights conferred under Article 11.
But how it does it is subject to the margin of appreciation.
Well, how it does it is not margin of appreciation. It can do it in many, many different ways. It's not about margin of appreciation. It's just about, you can do it by doing it in this way that they did, or you can do it by other ways. You can make representations in writing or whatever it is. There are numerous different ways by which you can respect that right.
Correct.
And discharge your duty. But the critical point for our purposes, when we're looking at ambit, and we will take this in stages, is that this is a case where, one, the applicant, albeit they were not able to avail themselves of one of the modalities, was able to avail themselves of another of the modalities, and therefore the full measure of their Article 11.1 right to be heard was respected. The full measure of it.
What do you mean by modality in the sense you just used?
Means. The means by which you do it. The means by which you allow somebody to be heard. So I can allow you to be heard by making written representations to me. I can allow you to be heard by having meetings with you. I can allow you to be heard in numerous different ways. What this case is concerned with is a trade union not being allowed to be heard in a particular way, but being allowed to be heard in another way, which the court finds is fully respectful, therefore, of their right to be heard, i.e., not only is there no infringement of Article 11, but actually there is no prejudice to the full enjoyment of the Article 11 right, because it is secured and afforded by an alternative means. So it then goes on to consider whether nonetheless, even though there is not the slightest bit of interference with the enjoyment of the right or prejudice to the enjoyment of the right, the situation nonetheless falls within the ambit. And it concludes that it does, because it's concerned with consultation. And consultation is one of the means by which enjoyment can be secured. Now, what do I take from that?
Well, that really is a fairly basic point, isn't it? That you don't have to have a substantive breach of the fundamental right.
It's not even a breach. It's any impact at all. It's any impact. It doesn't touch upon the enjoyment of that right. That right is totally, fully and utterly protected. The state's duty is fully discharged by affording the opportunity to be heard through other means. So there is no harm whatsoever. Now, one then asks the question, if one is dealing with a situation where Article 8 guarantees rights to enjoyment and a state measure interferes with that enjoyment, as opposed to it being a case where the state is under a positive duty to take some positive steps, why should it be necessary to demonstrate, if you could show that the measure actually has a bearing upon the core right, why should it be necessary to show that there is actually some prejudice to the enjoyment of that right? In our submission, this case makes manifest that you don't need to, if you are dealing with something that impacts on the very rights that are guaranteed by Article 8. So
The Belgian case is a positive modality case because there was a positive law.
Yes, I'm going to come on to other positive modality cases, because what we'll see...
But this was a positive modality case.
Yes, well, it was the first case where they talk about modality. It's different to the later positive modality cases because the court moves even further away from the core right, and it actually says where the state is entirely voluntarily doing something, where it's not obliged to do it, it's not a core duty.
Sorry, I understand that, but this is a positive modality case. The state did something positive to implement the respect for the right which has to be respected.
I understand that, absolutely, but also this is a case where it is having to do something. It is a positive modality about the discharge of its obligation. So we have your core right and a positive modality case here in relation to the core right. You then have, in later cases, and we'll look at them, positive modality cases which move way beyond the rights themselves, how the state discharges its obligation, and the court saying that actually even where the state is not discharging its obligation, there is no obligation, no positive duty on the state to do this under the right in question, Article 8, but it voluntarily decides to be very nice and chooses to do something which has a more than tenuous connection to the right, then it's within the ambit. Even again, if there's no actual harm suffered as a result of being discriminated against in respect of that measure. So, but we'll come to that. But at the moment, we are focusing on the core of the right, and where the core of the right obliges the state to take some steps, then a measure will be within the ambit even if the steps taken by the government to which that person is not a beneficiary do not in any sense prejudice that individual in the enjoyment of the right. The state is still required to justify it because it falls within the ambit. So if we look at that, the question I then ask is, why would Strasbourg treat differently a measure whose effect is to make it harder for somebody to secure accommodation, the securing of which, settled accommodation, is ultimately important in the enjoyment of the rights that Article 8 guarantees, the enjoyment of their personal life and their right to home and family. Why on earth would Strasbourg say, in respect of an interference which causes harm, it does not fall within the ambit? It makes absolutely no sense. In my submission, the court would take precisely the same approach and measure ambit by reference to precisely the same issues and parameters. And that's all the more so because, and we addressed this in our skeleton, and I'd ask your lordships to go back to it, because the distinction between positive modality or positive duty and negative interference, and I'm not talking here about modality, I'm talking about duty, the difference between positive duties being cast on the state and a negative obligation being cast on the state not to interfere are sometimes impossible to distinguish, and it would make no sense for there to be a difference of principle in the way that the court approached that question. So can I then come to how positive modality has expanded beyond the different ways in which the call right can be secured, or to actually nothing more than a tenuous connection with the right because the state volunteers to do something which is beneficial. And that Schmidt and Dahlstrom, which was 1976, is a very early case on that, and that is at tab 51. You could just look at the head note. And all you need to read down to is about 10 lines down, stopping when you get to the two organisations. And then if you could go to paragraph B on page 633 of the holdings, and read B, C, F and G. And then 2A. So here we're dealing with a situation where...
This is, as you would say, in effect the same point, isn't it, as in the previous case, the Belgium case?
It's actually different to Belgium, because Belgium, there's a core...
But the approach, you would say, is the same.
Well, the approach is exactly the same, but the distinction, the important distinction is this. The court says in terms, you don't have a right to retrospective payment of your salary under Article 11. Article 11 has got nothing whatsoever to do with that. So you cannot complain, you cannot bring yourself within.
Nevertheless, Article 14 comes into play.
And this is where the ambit expands. So it's just simply the fact that you were picked on because you were a trade union that means that this is linked to Article 11, because Article 11 is concerned with the rights of trade unions. The fact that Article 11 doesn't guarantee you this right at all, or protect you in any way, but the fact that you're a trade union means you're linked to Article 11, and that is enough. Now, to hold that it is enough that you simply are linked because you're a trade union to a right, but that where actually what is happening to you as BME tenants or foreign nationals is actually making it more difficult for you to secure a home, which is right at the core of protecting the rights that Article 8 is directly engaged with, is totally unprincipled and unsensible. Now, this marks the beginning of where we get this growth in positive modality cases.
And this is a positive modality case.
Well, it's not positive modality in the sense that they didn't... Well, it's positive modality in the sense that they didn't confer the benefit, but let's turn that around.
No. It's positive modality because they did confer the benefit. They conferred the benefit on some strikers,
That's what I mean.
but not all
they didn't
strikers.
confer the benefit on them. That's
The
what I mean.
conference of the benefit on some strikers, that's why it was a positive modality in the context of Article 11.
Absolutely. Let's turn it on its head. Instead of not conferring the benefit already existed. The strike takes place, and they then make a provision saying, we're taking that benefit away. Negative interference. Why would the situation be any different? Why on earth would you say, oh, sorry, you've suffered the same prejudice, it's still linked, and don't forget, all that was asked was link, But sorry, no, you're a negative interference case. Can I then take you to... And what this and the other cases then show is this, and it's made absolutely clear by Sir Nicholas Bratzer in the case of Zarb Adami, is that the court in Strasbourg takes an generous, incredibly generous approach, non-technical approach to Article 14. It looks for linkage. It doesn't look for prejudice in relation to the enjoyment of the right. It doesn't look for interference. It just looks for linkage.
I'm sorry, just to answer your rhetorical question. In the hypothetical, in the hypothesis that you put forward, isn't the answer, or isn't an answer this? If there was already this benefit for strikers already in existence, that's a benefit not required by Article 11, but one given by the state. There is a strike. What the government want to do is not to let that benefit apply to some strikers in a discriminatory way. They could certainly remove the benefit from everybody under Article 11. It's not a requirement of Article 11.
Well, it could do what...
But that's right, isn't it?
Yes.
And having taken it away, they could then restore it to some strikers. We know the answer to that because that's this case. That's a positive modality case. So that's how they could do it.
It's not a... My submission is, look, whichever way they do it, it doesn't matter whether or not...
I think you would say that's form over substance.
It's form over substance. This is a right, howsoever it is conferred. It is one that the state is not obliged to give. It's a present. And Article 14 attaches to presents. Why should it matter whether or not you take the present away or you don't give it in the first place? It really doesn't matter.
I understand that the emphasis you're placing on the concept of a link. Do we have any assistance in the Strasbourg jurisprudence on quite what is meant by a link in this context?
More than a tenuous connection. More than a tenuous connection. That is the language that is used.
With what?
With the right. With the substantive right. More than a tenuous connection. No prejudice, no harm, no interference with the substantive right, just more than a tenuous connection.
And the connection can just be treating some kind of vaguely related subject matter? Or?
Exactly.
Well, I mean, I'll put that as a question. But
Yes.
frankly, it's almost impossibly broad, isn't it?
It is very, very, very broad. It is a very generous interpretation.
Yes. I mean,
And then the state must justify it. And therefore, the broader, the further away it is, perhaps, is a matter that they take into account when it comes to justification.
so that's why ambit questions tend to be skated over,
Yeah.
because frankly, almost anything will do.
It's a very, very generous, untechnical test, a more than tenuous connection. And if your lordships will turn to Zarb Adami, because these are cases that concern Article 4 and the language of Article 4.
Which tab is that?
Zarb Adami is tab 62. It concerns Article 4. So if your lordships have tab 1 open as well of the first bundle, Article 4, prohibition of slavery and forced labour. No one shall be held in slavery or servitude. No one shall be required to perform forced labour or compulsory labour. So that's the key provision. No one shall be required to perform forced or compulsory labour. And then, for the purposes of this article, under 3, the term forced or compulsory labour shall not include the work required to be done in the ordinary course of detention, or, and B is the important one, yes, D is the important one. Any service or work which forms part of normal civic duties or normal civic obligations. So that includes something like jury service. So we can see that Article 4, the core right, does not apply to somebody who is performing normal civic obligations. You are totally outside the scope of Article 4 if you are performing those obligations. And what we see in the case law repeatedly is the court holding that somebody who is by definition excluded from the core protection is nonetheless somebody who falls within the ambit of the right. Now, why are they doing that? Because of the generous, tenuous link, more than tenuous link. And the tenuous link in some analyses is because in order to define those who are included, the words of the article itself make reference to those who are excluded. Well, that's an interesting analysis, but what it does show is that it is a very, very generous approach. And Sir Nicholas Bratzer, in this case, tried to give some thought to what is going on with ambit in Article 14. And he starts on page 67 at OI1. And where he goes from there is, I'd ask your lordships to read all of that in your own time, but just to summarise, that what he does at 012 to 013 is he carries out an analysis of the court's previous case law on compulsory service cases, and at 014, unsurprisingly, and I share his view, he says, I do not find the reasoning in either judgment for holding Article 14 to be applicable to be entirely convincing or satisfactory. And what he then does at 016 is to conclude he's nonetheless going to follow those cases, and thereafter he seeks to address how the court really does approach ambit and why. So, if your lordships will turn to 016 and then read 017 in its entirety. So he's speaking to its generous and non-technical application, even to a case where you are expressly excluded. Your only relationship to Article 4 is that it doesn't apply to you.
But the core right in Article 4 is, if you put it in terms of rights, is a right not to be required to do forced labour or slavery or whatever. That's the core right. There are certain exclusions, civic duty. But if a particular state decides not to apply that exclusion, so to include within the right not to be required to do forced labour, civic duty, that's still, isn't it, in furtherance of the core right. That's the right not to be required to do forced labour. That's the purport of OI 7, paragraph 7.
No, the right not to be required to do forced labour only applies to the cases that are not excluded. And if
that's the
you
that's the four corners of the Article 4.
Yes, and therefore, if you're excluded, Article 4 doesn't apply to you. It's as simple as that. It just does not apply.
No, I understand that.
But nonetheless, you're within the ambit.
But the core right is not to be required to do forced labour. That's the core right.
No, the core right is not to be required to do forced labour unless you are, because part of the definition of what of the right is by reference to Article 4.3, who defines who's excluded. So even there, the court is, even if it has unambiguously no application to you, you nonetheless can bring yourself within the ambit if you are required to do forced labour, despite being. So it's obviously not on all fours with this at all, but it's just an example of how generous the ambit test is. Can I look then at the Sidabras case in Lithuania at tab 61. This is something that we looked at yesterday. Mr. James took us to. This is the KGB ban. And if you turn to paragraph 47, so what happens is they're banned from all public sector work and banned from some private sector work because of their former KGB employment. So they go on to say, so we all know that private life does not entitle you to a job, and that therefore, in most instances, any impact upon your employment by virtue of a measure does not, as it were, bring you within the scope of Article 8, and certainly doesn't constitute an interference. If it's a profession, that's a different matter. But here at 47, given the measures that were applied to him, having regard in particular to the notions currently prevailing in democratic states, the court considers that a far-reaching ban on taking private sector employment does not affect private life. Does affect private life, I'm sorry. So they're saying it affects it. They don't use the word interference.
I'm sorry, which paragraph?
It's paragraph 47 at the bottom.
Thank you.
No, at the top.
That includes a further restatement of the principles. Do you ask the question, does the measure in question affect private life? Well, yeah, well that's broad, isn't it?
That's broad.
Yeah.
Very broad. Hence, and in view, this is at paragraph 49 at the bottom.
Had so many debates with council over the years about within the ambit under Article 14, and I'm still not any the wiser. And I won't be after this case either. Right. Anyway, but what you're saying is, look, whatever it is, it's broad.
It's really broad. It's really broad. But also one can't take from this case, one can't from this case say that because they actually found that there was a very significant, it was a significant measure that had an effect, that it's only when it is this significant that it can be within the ambit. That is not what this case says. At paragraphs 49 and 50, all the court does is observe that it is having a significant effect, and because of that, it affects the enjoyment of private life. But to turn it on its head and then say, you need this kind of interference or this kind of effect and adverse impact before you can bring yourself within the ambit, is to treat this as authority for a proposition that is simply not made within it. And that takes me very quickly to M and the Secretary of State for Work and Pensions, authorities 12, in the first bundle of authorities, and to the speech of Lord Walker. I should say that Lord Walker, this was a case where all the judges gave judgment, so this isn't the ratio of the case in any way, shape or form. But if one looks at that paragraph, 83, you can see, skipping quickly through, that he makes reference to the Sidabras case and says banning a former KGB officer from all public sector posts and from a wide range of responsible private sector posts is so draconian as to threaten his leading a normal personal life. Less serious interference would not merely have been
And then we agreed not have.
not a breach of Article 8, it would not have fallen within the ambit of Article 8 at all. Well, the court didn't decide that at all. The court simply made a statement to the effect that there was a serious, it did have a serious impact, but it didn't say had it not done so, it wouldn't be within the ambit. It's simply not something you can extrapolate from that decision.
But is it your submission that what is there stated is wrong?
Yes, It is my submission that is wrong. It simply does not sit with the very first case, one of Strasbourg's earliest cases on this issue, the case that I started with, relating to the National Union of Belgian Police, where there was absolutely no impact whatsoever on the enjoyment of the right, and it was within the ambit. So can I just very briefly turn to our cross appeal before saying how all of this then on a fallback position is such that Mr. Justice Spencer's judgment is unimpeachable. So our cross appeal is that actually on the findings made by the judge, there was an interference with Article 8 rights because of the extent of the difficulties that would be faced by some people who were being discriminated against. Impossible to find a home or such.
Just look, if you're right on ambit, you don't need this.
No, this is all part of. No, I don't. Absolutely. If I'm right on
And
ambit.
if you're wrong on ambit, how can you succeed on your respondent's notice?
Oh, because it's not contested by the appellant that if there is an interference, then it's within the ambit. Yes. If the adverse impact is sufficiently great to constitute an interference with the enjoyment of the right, then it is accepted by the appellant that you are within the ambit. Unsurprisingly.
Of course.
Yeah, it necessarily follows.
I see.
So that's why, even if we lose on ambit, this is still a point.
I see.
Just before we move on, just to make sure I've got this right, do you say that Sida Brass and M are negative modality cases?
Yes, they're an interference case. They're preventing him from getting work.
Sorry, I thought that was right. I just wanted confirmation.
Well, they're negative interference cases or modality if it doesn't constitute an interference, yes. So the starting point is what is Article 8 protecting? What are the rights that are protected in Article 8? And the judge took a perfectly proper view of that at paragraph 46 of his judgment, page 66.
Sorry, again, which paragraph?
Paragraph 46, page 66. And he cites two oft-cited authorities on what is it that Article 8 is protecting, what are the rights that it requires the state to secure the enjoyment of. And AMV in Finland is, as I say, oft cited. It secures to the individual a sphere within which he can freely pursue the development and fulfilment of his personality. It concerns rights of central importance to the individual's identity, self-determination, physical and moral integrity, maintenance of relationships with others, and a settled and secure place in the community. Those are the interests that it is protecting. And the judge also looked, in his judgment, at what the government itself had said about the scheme insofar as it was going to affect those against whom it was targeted. So, irregular migrants. And that's in paragraphs 96, 98 and 99 of his judgment, and the relevant, it's cited by him at paragraph 11 of his judgment, I'm sorry, but the relevant paragraphs of the Home Office memo that he there cites are on page 181 of the supplementary bundle. And if your lordships will read 96, 98, the first 4 lines, and 99, the first 5 5 lines.
Yep.
So, not just in some sense has a tenuous connection with, but actually interferes with the enjoyment of those core rights, because it's going to make it impossible for individuals to maintain their relationships with their friends, family, to enjoy a family life, to enjoy a home, if they actually aren't able to find one at all. Now, as we've discussed, the judge's findings are such that he is of the view that there are some individuals who are effectively subject to the same effect, albeit not intended that this should happen, but that self-same thing is happening to them. And even if it's not as extensive in that they literally cannot find a home, it is taking them so long to find one that that is going to have a detrimental impact on the enjoyment of those self-same rights. Can I take you briefly to the case of Barr in the United Kingdom at A69?
This is a frequently cited authority.
Very frequently cited, and we won't dwell on it for very long.
Yeah.
So, quick view of the head note to see what it concerns.
Yes.
And then at 40, 5 lines down, after the words with Article 14, the impugned legislation in this case obviously affected the home and family life of the applicant and her son, as it impacted upon their eligibility for assistance in finding accommodation when they were threatened with homelessness. They didn't actually suffer any homelessness in this case at all. They were accommodated. And then, briefly, can we also look at H and Ealing London Borough Council at Authorities 35. My Lord Justice Davis mentioned yesterday that you disagreed with what was said by the Master of the Rolls at 100, but if we can just go there and we'll look at each of the judgments just briefly. So, the Master of the
Where are we
Rolls,
going to now?
I'm sorry, that's tab 35, Authorities 35.
35, I'm so sorry.
And if we can go to page 100. So,
Yeah.
the Master of the Rolls says, Mr Justice Goss addressed Obiter whether the policy discriminated against women who were victims of domestic violence contrary to Article 14. He held that it did. He explained that the link with Article 8 is as follows. The link here is said to be home and family life. There is no enshrined right to a physical home. The right is to the enjoyment of family life. However, this can in reality only be enjoyed in settled accommodation. Accordingly, I am satisfied there is a sufficient link. And then, at 102, he says the position in relation to WHPS is different.
Yes, 101, the Master Rolls interest use language. He also does it have, quotes, anything to do?
Yes.
That's the language he uses.
It doesn't have anything to do with core value.
The core value, but yes.
Yeah.
Yep.
And that's in relation to the MTPS scheme.
Which is a
So, yes, this is the MTPS scheme where what's in issue is being transferred from one house to
absolutely,
another.
absolutely,
Yep, so it's a completely
absolutely.
different situation, and he's
Absolutely.
saying it's got nothing to do
Absolutely.
with it. And then, so that's the tenuous link test. Absolutely not even that generous test is engaged. Position regarding the WHPS is, however, different. First, looking at the matter generally, so far as concerns single parents with children who are not already in secure accommodation, or indeed not accommodated by anything at all, their right to permanent accommodation falls within the scope of family life protected by Article 8. And then at H, thirdly, in accordance with the principle in Barr's case, since local authorities are bound to provide the homeless in priority need with accommodation and homelessness is related to the enjoyment of family life, then they must do so in a non-discriminatory way. And then at 132, the Justice Underhill says, the essential basis of the judge's reasoning on this point, following the observations of Mr. Justice Goss, quoted above, is that the two schemes impact on the way in which access is afforded to settled accommodation or stable permanent accommodation. The enjoyment of settled accommodation is said to fall within Article 8 because family life cannot be enjoyed without it. The Master of the Rolls accepts that analysis as regards WHPS, though not the MTPS. But it depends on what is meant by settled accommodation. I agree that family life cannot be enjoyed if the family is in precarious accommodation, which such that they cannot be sure from day to day, week to week, whether they still have a roof over their head. So it's that precarious situation that, in his view, leads to the conclusion that you can't then enjoy family life. So it's a proper interference in that situation, a full-scale interference. And at 1 to 8, my Lord Justice Davis said, in relation to WHPS, don't accept it's within the ambit. In particular, I do not, as at present advise, accept that there is, for these purposes, a right to settled or permanent accommodation protected by or within the reach of Article 8. Now, that's right. There isn't any right to such accommodation. There's no duty on the state to do that. But if something is interfering with your ability to secure
In truth,
it...
I was doing a different point. I was just saying, don't take Mr. Justice Goss too far.
Yes.
I was just putting on a marker.
Yes.
And that's really what I was doing. I wasn't really dealing with this particular
Yes.
point arising in this case at all.
So what we're dealing with here is a situation where we don't contest, argue that there's a right to a home under Article 8,
No,
and
you
there's
don't.
no right to a home.
No, absolutely.
But an interference or a measure that is a negative measure, that is, that stops you from doing something, is capable of interfering with the rights that are conferred under Article 8, and that is your rights to enjoy
Private life.
private and family life and a home. And that is what the judge found, and even if what is happening here is that it's making it harder for individuals to secure new accommodation, then in our submission, those individuals will suffer an adverse impact and, on the judge's finding, unquestionably, an interference with the very core rights that Article 8 is aimed at protecting.
Is the point that if there's an interference that stops an individual obtaining settled accommodation, that is, that puts an individual into a precarious situation so far as accommodation is concerned, that's the point, really.
Yes, exactly. You're doing something. You, the state, are doing something, as the state recognised in relation to illegal migrants, unregulated migrants, to whom these provisions are directed. That what you're doing by stopping them from acquiring a home in the private rental sector, given that they also can't secure any housing assistance, is that you are interfering with their Article 8 rights, because you are putting them into this situation where things are so precarious for them that they can't exercise family life and so forth.
Again, not to go backwards, but again, the note on what the default position is very important.
Yes, yeah, we will get that and get it agreed. So That is the way in which the judge identified that Article 8 is effectively brought into play here. Not because there's a right to home, he didn't make any of those sorts of mistakes, but on a proper assessment of how those fundamental core rights are adversely affected by these measures, these discriminatory actions of landlords. So that then, my lords, is ambit. We're now on to justification. Then we have declaration of incompatibility and declaration of irrationality. So I will definitely be finished this afternoon without question, and I hope by 3. I hope. I may run slightly over, but I hope. So can we come to justification?
Yes.
So, as we noted in our supplementary skeleton, the test for justification has moved on since this case, because this case proceeded on the basis that the manifestly without reasonableness test applied, but when it came to fair balance, the fourth of those questions the court has to ask in seeing whether a measure is justified: does it pursue a legitimate aim? Is it the least intrusive means, and so forth? Then on the fourth question, whether it strikes a fair balance, the court proceeded on the basis that it was allowed to itself make that assessment, obviously giving due deference to the balance struck by the state. And the DA case makes clear, as we saw yesterday, that the sole question in respect of the application of that 4-stage test is whether or not the measure is manifestly without reasonable foundation. Now, whilst the judge was permitted to make that, or to take that approach, the parties were agreed on the appropriate approach, he nonetheless did find that it was manifestly without reasonable foundation. So he did actually apply the DA test, and we'll see that when we come to look at his judgment. But can I start by looking at the case law on manifestly without reasonable foundation and how you approach justification applying that test, because there's some useful Court of Appeal authority on this, which predates and postdates the decision in DA. So DA is something we just need to look at very, very briefly at Authorities 43 to remind ourselves of how the test was put by Lord Wilson. And that's at paragraph 66. So, your Lordship will recall there was in his discussion, he looks over his old judgments and says, I made a mistake, I was wrong in concluding that the manifestly without reasonable foundation test does not apply to the fourth question to be asked in the justification exercise, namely fair balance between the aim and the adverse impact. So at 66, how does the criterion of whether the adverse treatment was manifestly without reasonable foundation fit together with the burden on the state to establish justification explained at paragraph 50 above? For the phraseology of the criterion demonstrates that it is something for the complainant rather than for the state to establish. The rationalisation has to be that when the state puts forward its reasons for having countenanced the adverse treatment, and one has to address that, its reasons for having countenanced the adverse treatment, it establishes justification for it unless the complainant demonstrates that it was manifestly without reasonable foundation. By reference in this context, to any burden, in particular to a burden of proof, is more theoretical than real, the court will proactively examine whether the foundation is reasonable. And it is fanciful to contemplate that it's concluding that, although the state has failed to persuade the court that it was reasonable, the claim failed because the complainant had failed to persuade the court that it was manifestly unreasonable. So, whichever way, wherever the burden lies, the court is going to proactively examine the justification to see whether it's manifestly without reasonable foundation. And we looked yesterday at the case of Langford. I think we didn't look at Langford, but we're going to look at it now. This is a Court of Appeal case, post-dating DA, and it is at tab 46. judgment is given by Lord Justice McComb, and if your lordships note that sitting together with Lord Justice McComb were Lord Justice Leggett and Lord Justice Baker, and Lord Justice Leggett's presence is relevant for the next case that I'm going to come on to. So here, I'd ask the court to turn to paragraph 50, where the court cites paragraph 66 in DA, and says at the bottom, after the quote, "In my judgment, this paragraph gives lower courts, including us on appeal, a clear practical guide as to how one should approach the manifestly without reasonable foundation test in any individual case." And then at paragraph 54, he says this: "In my judgment, while accommodating fully what Lord Justice Leggett said in the SC case, one could satisfactorily address the issue of justification of the discrimination in this present case by adopting the approach offered by Lord Wilson at 66. And I will assume that the manifestly without reasonable foundation test is indeed to be applied in this case in the manner that Lord Wilson indicated." So what I'm asking you to note there is that he accommodates fully the observations of Lord Justice Leggett, and we're going to come on to those observations in a moment in the case of SC and the Secretary of State for Work and Pensions. But if you can then turn to paragraph 56, and you can see here the court carrying out a proactive examination of whether the foundations put forward, or the reasons put forward, establish that the measure was manifestly without reasonable foundation. And I'd ask your lordships in your own time to look at the rigour with which they examined that. And your lordships will see at paragraph 67, they found in this case, despite the reasons put forward, that on proactive examination, I do not find that the foundation for the clear discrimination in this case was reasonable, and in such circumstances, it seems to be fanciful to find the claim should fail because the discrimination, although unreasonable, was not manifestly so. So we then turn back in time to the SC case, which is what Lord Justice McComb was referring to in relation to Lord Justice Leggett's observations, and that's at 45. If your lordships will turn to paragraph 88, even though this predated DA, your lordships will see that the court applied the manifestly without reasonable foundation test. And I then ask your lordships to read all of 89 and 90 and 91 down to 92 to the quoted passage.
So we're going back to it. Can I invite you to read to the end of 93, just so you get all of the factors that he's relying upon?
Yes, I was going to take it. So
Yes.
even if it pursues a legitimate aim and is the least intrusive means to do so, it can still fail the manifestly without reasonable foundation test if it can be shown to be manifestly disproportionate to the legitimate aim. That's 89. And the intensity of review, this is 90, varies, and he identifies 3 relevant factors. At 91, the basis of discrimination. So where one is talking about race discrimination, that is a significant factor. And I remind the court yesterday of what Strasbourg said in DH, that race discrimination can't be justified. Now, the fact that this was causing race discrimination was a very significant factor in Mr. Justice Spencer's judgment. It was one of the matters he took into account in looking at whether there was manifest disproportionality. And I, for your Lordship's note, highlight paragraphs 122 CB 98 and 123 CB 98. And he accepted at 123 the reasons put forward by the applicant, and one of those reasons at paragraph 109, 1 and 2 of his judgment, where he sets out the reasons that we submitted the scheme was manifestly disproportionate. 109, 1 and 2 relate to the ground of discrimination. Going back to paragraph 92 in the SC judgment, second consideration is whether the relevant measure resulting in differential treatment has been approved by Parliament. And the judge's conclusions looked at precisely this as well. It was a matter we addressed at 109.4 and 109.5 and paragraph 110. Now, what Parliament did, there's no question, of course, Parliament addressed its mind to the legitimate aim of the scheme. But what Parliament didn't address its mind to was the cost in terms of discrimination. It did not weigh up itself the proportionality of pursuing the scheme for the reasons it wanted to advance it against the cost of landlords discriminating in the way that they have in fact discriminated, because the government, and we saw how seriously it repeatedly took the risk of discrimination, not the actuality, because it expected, and Parliament expected, that the measures would prevent discrimination. They would mitigate that risk, stamp out that risk. So, yes, Parliament considered it, but it didn't decide to go ahead with this, fully confronting the actual cost.
Well, are you saying that Parliament's consideration is to be taken as vitiated by subsequent events as they turned out on the ground?
It's not so much vitiated, it's how much weight do you give to Parliament's consideration in the balancing exercise. So where Parliament operates on a basis where it, as it turns out mistakenly, considers that this particular issue isn't going to arise because measures have been taken to avert it, and those measures, that consequence does in fact arise, then it's not that its analysis or its balance is vitiated, it's that it hasn't struck the balance, and therefore when one gives greater deference to Parliament's considered view, it speaks to that.
But are you saying that the balance wasn't reasonably struck at the time the legislation was passed?
No, that's not the submission. So the question is, when the court is now looking at justification, ordinarily it will, where Parliament has confronted the issues in question in striking the balance, give Parliament a wide or defer give substantial deference to Parliament's view. But whereas here, Parliament's view was formed on the basis of what turns out to be a factual misapprehension in terms of how the scheme has actually turned out.
Well, it's just this point. This point gives rise to something Lord Justice Henderson alluded to earlier this morning. I mean, you see,
Well,
for all one knows, very few, very high-profile, successful discrimination cases in the county court might operate to change the attitudes of landlords very markedly.
The question arises, how are those high-profile discrimination cases to be brought in the county court?
No, I can understand that, but all I'm saying is circumstances can always change.
Well, one of the things that one is going to have to ask at some stage, or your lordships are going to have to ask, is whether or not the circumstances can change in relation to this scheme. Now, Sir James has himself said on multiple occasions in the last 2 days, well, yesterday, what else could they have done? What else can be done to stop the discrimination in this scheme? And that is, our submission is, no, nothing could be done. There isn't anything that is going to...
The whole scheme just
Yes, it
is
is the
unruffled.
scheme. It is the scheme, but let's
Indeed,
bring
one
ourselves...
wonders how any scheme intended to stop people with no right to be in the country securing rented accommodation could ever work on your argument.
Well, we discussed this yesterday.
We did, and I'm still grappling to see how on your argument you could ever have a scheme that would be compatible.
Well, a scheme which criminalised intentional letting would be an example of a scheme which, in my submission, would be very, very likely to work. In practice, it is... one can... Obviously, one has to see how...
It's not for us to second guess the legislature, is it?
That's exactly
There
the
is a
point.
constitutional issue here. I mean, the division of roles between Parliament and the court.
Well, we're going to come on to a declaration of incompatibility later, and that's the role of the court would be, do we declare it?
Even at the justification stage, and it's a very strong thing to ask us to say, although Parliament expressly took all these problems into account, you say they just didn't produce an adequate answer, as we can now see in the light of experience.
Yeah.
I mean, that is a very strong submission to ask us as judges to accept, and it's very liable to lead to accusations of judicial overreach and matters of that sort. Now, of course, we have to apply the law, but we do also have to have a very clear recognition of the proper division between the functions of Parliament and the courts.
And that is something which I fully accept. The question then is, if Parliament has not confronted itself, the particular, head-on, and identified it as a cost because the discrimination can only arise as a matter of implementation, which is the nature of this scheme, and we've already addressed why, according to Strasbourg, it doesn't matter, or the fact that this is legislation does not prevent the court from judging its compatibility by reference to its application. If, as a matter of fact, Parliament did not confront this cost head-on and carry out that balancing exercise itself, then the court is not usurping Parliament's function in saying this is a matter it didn't take into account, it couldn't. It perhaps reasonably believed at the time that its measures would have the desired effect. It turns out its measures haven't had the desired effect.
That's right. I know we're coming back to points courts have touched on before, but if that's right, the slightly worrying implications, if you're right, is that the courts might be seen to be in effect sanctioning breaches of the law. Because what has happened here arises because landlords, for their own economic reasons, have chosen not to do what Parliament has asked them to do. And so if you're right, the courts will in effect be saying, in effect lending support to the landlords in their stance, which involves a breach of the law.
It's in no sense lending support to the landlords, but it is saying...
Well, it is, isn't it? It's in effect saying, well done, by not obeying the law, you've succeeded in getting rid of an act you don't like. That's quite a big thing to ask courts. I'm not sure the judge quite appreciated the enormity of what he was doing.
If the court concluded that landlords are just willy-nilly choosing to ignore this law, we don't like it...
well, they are, if it suits their own economic reasons.
Well,
they've admitted it.
No, what they're doing is they are just taking an extremely risk-averse approach, which is exactly what one would expect, given the risks that they face in the event that they were to apply the right-to-rent rules. And that is something that they are doing, again, because of the government's own action. So you have to come back to the fact they would not do this but for the introduction of this scheme. And the court is saying, by so holding, Parliament, we are inviting landlords and in fact condoning landlords breaking of the law. What the court is doing is saying this is a consequence that the government did not expect to result. It thought it had done what it could to ensure that it didn't happen. It's failed in that regard, and the cost, the unintended cost, the unforeseen cost, is that landlords are unlawfully discriminating against British nationals because of their race, to the point where they are finding it
But if landlords
difficult.
do what the legislation requires them to do, if the landlord follows what the code encourages them to do, if the landlords use the helpline if they're in doubt, they will not break the law.
This is indeed right.
So
But
why don't they do
landlords-
it? So why don't they do it?
But landlords are not doing it. And
Right,
that
but
is
what
the
the-
fact.
But why should they take advantage of their own refusal to comply with what is open to them to then set aside the law and then use the courts for that purpose?
Well,
It's
they're
a
not
very
using
troubling
the courts.
proposition.
They are not using the courts. The people who are using the courts, JCWI, is doing so on behalf of individuals who are British nationals.
Yes, well, I
who
do.
are-
I follow that. Yes,
Yes,
I do. Follow.
and the state has a responsibility for that, and the state has to, whether landlords should do it or not. We're all agreed. Landlords shouldn't do
I should
this.
be directing probably this tone of questioning to Mr. Bates, and he can put his suit of armour on in advance. Yes.
Landlords shouldn't do it. Landlords are doing it. Landlords are doing it because the scheme incentivises them to do it. The justification for this has to confront head-on the reality on the ground. The government did not, in introducing this legislation, consider that this was a cost worth paying. It didn't address this cost and say, even if it means that black and ethnic minority British citizens are going to find it harder to find a home, it's a cost that we think is justified. It simply didn't confront that, and that is the basis upon which, bringing us back to the submissions I was dealing with in Lord Justice Legate's judgment, that is the basis upon which less deference is required to be given to the balance struck by Parliament than would ordinarily be the case, because they didn't strike a balance here.
Just on that, you accept that Parliament had the risk in mind,
Yes.
that they knew of the measures that were being taken to eradicate or mitigate the risk. They knew of those measures. And they believed that they would be effective.
Yes.
What they were wrong is, if other submissions of yours are correct, is that the mitigating factors have not proved as successful as Parliament had hoped or believed.
Yes.
That-
And therefore, you have to ask yourself, so what costs, when it was weighing the scales of the legitimate aim against its adverse impact, what did Parliament put on the side, the adverse impact side of the scales?
I understand that.
And it didn't. It didn't put the cost that has actually materialised on the side of the scales.
I tell you what, Miss. I tell you what, Miss Scuff, one normally has a few peppy exchanges between counsel and judge just for lunch, so let's have lunch. 2:05.
Otherwise,